Welcome everybody to today's HLAA webinar, Hearing Accessibility and the Law, Your Rights and How to Obtain Them. Thank you for joining us today. My name is Amanda Watson and I am the meeting planner for HLAA and your host today. This webinar is presented with the HLAA New York State Association and it is sponsored by TracFone. So thank you so much, TracFone, for bringing us this webinar today. Today's presentation is being recorded and will be available for playback at a later time on the HLAA website at hearingloss.org. To see captions on this webinar, you will need to click the CC icon and click on Show Subtitle. You can change the font size in subtitle settings. Chat is available for technical
Amanda, you froze on my computer.
Jerry, this is Tim Browning from HLAA. Amanda just texted me. She's having computer issues, obviously. So I would suggest to just get started.
Okay. I was going to thank Amanda. Welcome everyone to this advocacy seminar presented by HLAA New York State in cooperation with the National Office. Close to 500 or even 500 people registered for this event, which is very heartening because it suggests that grassroots advocacy by those of us who face barriers to communication is in our daily lives is alive and well, at least to some degree. The chief message of this seminar, we don't have slides from Amanda, but we'll make do if we have to without them, is make your voices heard both individually and along with others. We've allotted half of our 90 minutes to presentations by our three panelists, whom I'll introduce shortly. Their remarks will be followed by an equal amount of time for question and answers. Please use the Q&A tab at the bottom of the screen to direct your suggested questions to me. I was going to start with a brief video. If we ever get Amanda back, I'll stop what I'm saying and we can show the video. What the video message I wanted to ask you is as we celebrated recently the 30th anniversary of the passage of the ADA law, think about what the ADA has done and what remains in terms of our needs. Founder Rocky Stone cautioned us shortly after the ADA was passed in 1990 that the ADA was only enabling. It was up to us to try to make it happen in reality. The actual quote is with Amanda. Sorry you can't see it. A good example of the limitations of ADA and other laws and ordinances that you might hear about in a little while is that many of those of us with severe to profound hearing loss cannot process sound effectively via infrared or FM listening systems. Neck loops can help only somewhat, even when we hold them at ear level. I had wanted to show a chart that illustrates that, and maybe we can put it up later if time permits. It illustrates the dilemma we face. Our best option is to continue to be advocates for hearing loop systems for people with telecoils and to encourage audiologists to recommend telecoils to their clients and ask manufacturers to stop promoting the benefits of invisible hearing aids that don't come with telecoils. I know some of you out there tonight prefer captioning. All of us love captioning as well as being able to listen when we can. It's a blessing that live theater on Broadway now and in more and more out-of-town locations are offering something called the GalaPro phone app to deliver well-timed captions inside theaters. You can Google the GalaPro if you're not familiar with it. Here you see now the slide I wanted to show you, which is a little chart I created that simply indicates for people who have a desire to hear in large venues how hearing loops can be accessible to all people, including those without telecoils in their hearing aids via a receiver and a headphone. CART captioning, again, works for everyone. However, it's a myth that some have perpetuated, particularly some Bluetooth aficionados, that Bluetooth is currently, technology is currently available for large area listening systems. It's not, and we think it's at least 5 years, perhaps more down the road before they solve some of those problems. But to continue, our three panelists tonight are attorneys who've spent years helping to achieve accessibility for people with disabilities. John Waldo, our first speaker, is a prominent member of the Disability Rights Bar. John has done much work on behalf of people with hearing loss, particularly so we have access to captions in movie theaters, where he was indeed a pioneer some 10 years ago. John Herrian, our second speaker, has served as Director of Disability Rights for the New York State Division of Human Rights. He assists with enforcement of human rights law provisions that prohibit discrimination against people with disabilities. Our third speaker, Mark Fleidner, is Director of the Protection and Advocacy for Individual Rights Program at the New York City Office of Disability Rights, New York, part of a nationwide network of legally based disability rights agencies mandated by federal law to protect and advocate for individuals like us. I'm going to now turn it over to John Waldo for his prepared remarks. John?
Thank you, everybody. Can people see me? I can't see me. Can everybody else?
We can all see you.
You can
see you, John.
I know what I look like. I don't need to see myself. That's okay. We just flashed very quickly on that quote from Rocky Stone. And Rocky there said something I think is very important. He said, ADA is a tool. And I think that is precisely the way to think about it. But, you know, tools can do marvelous things, but it requires that we know two things before we can make use of that tool. First of all, what can the tool do? Secondly, how to use it. What can the tool do? Basically, it can provide us with effective communication if we use it correctly. How do we use it? I use a three-step process. Can I have that first slide about the three-step process? There we go, yes. The first step is basically, that's the second slide. Can we have the first one for a minute? Perfect, that's the one. First of all, I normally ask the client, the individual, or the group to contact the entity in question, explain what is needed and why, and ask for cooperation. Now, sometimes I help draft those letters, but they're always sent by the client. This is really important because remarkably, there are a lot of people that don't understand what it is that our group needs. What I run into an awful lot with that first contact is people say, hey, wait, we have assistive listening systems and we offer sign language interpretation. What else is there? So the first thing to do is explain what else is there, who we are, that we are this rather large group that falls between those who find enhanced audibility, assistive listening sufficient, and those of us who use sign language. We need something else. But we tell them what we need. One thing that's really useful to include in that initial contact when you can is if there's somebody else you know who is doing what you want done, some other company that's in a similar business, tell them about that. Tell them, here are people you can talk to and find out from them exactly how they're doing this. That can be really powerful. If that doesn't work, and sometimes it does, but the reality is not all the time. In fact, not very often. Second step, I then write a letter on behalf of the client. And this is the first time I talk about how, guys, it's not only the right thing to do, but you also have some legal obligations here. And it's that step that normally prompts negotiations and discussions. Sometimes they're heated, but usually this leads to a resolution. Now, where the heated part normally comes in is one defense to the obligation to provide effective communication through things like captioning, interpreters, loops, and so forth, is people will say, hey, wait, the ADA says I don't have to do it if it would impose an undue burden. And not surprisingly, the people we're talking to usually have a very different idea of undue burden than we do. They focus on the burden part and think that anything that costs money is too much. We focus on the undue part. What I try to explain to them is, look, sorry guys, the world isn't completely fair in this instance, but this is a situation in which it being unfair works in our favor. And here's why. We don't have to prove that you can't afford it. You have to prove that you can't afford it. Now, how are you going to do that? Basically, undue burden matches resources versus cost. And the Department of Justice has been very clear that this is a multi-factor analysis that means you got to go to trial. So what I tell them, and this is the unfair part, I say, look, guys, if you want to argue undue burden, you're going to have to go to trial. That's expensive. Number two, you're going to have to produce all your financial information, which you may not want to do. Normally, we get it settled at that point. If we go to trial, then I have to tell them, look, guys, here's the reality. If you win, it's going to be expensive for you because you got to pay your lawyer. If you lose, it's going to be doubly expensive because you got to pay your lawyer and you got to pay me or the plaintiff's attorneys. So it gets doubly expensive. Think about that. And they start saying, it actually could cost us more to worry about this, to fight about this, than to actually make it work. At which point I tell them, yeah, that's what happens every time. The fight is easier than the fix. So just do it. And a lot of times that gets it done. Now, when we do have to file a lawsuit, the lawsuits I file, first of all, I never ask for money damages. What I ask for is the fix, provide accommodation. Then, of course, you do have to pay me. That's part of it. We've got to go to the trouble to go to court. You got to pay me. But we don't ask for damages. And I think actually that helps kind of continue a cooperative relationship, sometimes even after the lawsuit is over. The other reality is that filing a lawsuit, one benefit it has that almost nothing else does is when you file a lawsuit, that will find its way to the desk of the person who has the power to say yes. And that's when the real communication starts. So that's kind of the way it works. Now, who has to provide effective communication? First of all, any so-called place of public accommodation, that is a business open to the general public, a brick and mortar business. Any government entity has to provide effective communication.
Amanda, can we have John's second slide?
We have a second slide. Let's.
3 sources.
We're not quite there yet, Jerry. Yeah, not quite there yet. But okay, so what I was talking about is who can you get effective communication from? The real question mark at this point is basically websites that are totally freestanding, that are not connected to an actual brick and mortar physical place or to a government entity. That's where it gets tricky when we're talking about somebody like Zoom. Do they have to? Do they not? Are they a place of public accommodation? Are they not? Maybe not under the ADA, certainly not in some parts of the country, maybe under somebody's law, and I think some of my colleagues are going to address that issue. So anyway, the freestanding websites are an issue. Now, the ADA is a tool that can have some surprising applications outside of this particular area. One I want to mention, although I don't want to dwell on it, is there was a case in Washington State filed a couple of years ago claiming that the ACA, Affordable Care Act, better known as Obamacare, it has a provision that prohibits discrimination on the basis of disability. Well, some attorneys there said, all your policies, all your healthcare policies exclude hearing aid coverage. That discriminates on the basis of disability. Well, that went up to the Ninth Circuit Court of Appeals, and, maybe so. The question we want to know is, are people who use hearing aids pretty much all people with disabilities? And the policies do cover cochlear implants. Do they, in fact, cochlear implants serve the needs of most people with hearing loss? So that's where the attorneys who were involved invited me to join them, because I know something about hearing loss. And, I'm very encouraged. The Affordable Care Act adopts the definition of disability in the ADA. So you're kind of playing on our turf there. And that definition says that a disability is an impairment, which, we've probably all seen Frank Lynn's statistics about the prevalence of hearing loss. Frank is measuring impairment. But the ADA definition of disability says it's an impairment that significantly limits your ability to engage in meaningful daily activities, which include things like learning, like speaking, like work, like school, like hearing. So yeah, when do people get they get a hearing aid only when they actually find that they are somehow limited in what they want to do. So I think it's really going to be pretty easy to argue that hearing aid is coextensive with disability, and that cochlear implants serve only a small portion of the affected group. I think we've got a real chance on that. And if we win, that would basically mean in the Ninth Circuit, which covers the whole West Coast, health insurance policies are going to have to cover hearing aids. So that can be pretty cool.
John, can you wrap it up?
Get help. Let's go to the last slide, and I'll make this really quick. Final slide. Yes. Okay. Oh, no, I'm sorry.
You only had 2 slides, John.
Okay, that one. My colleagues will talk about 1 and 2.
Thank you. Before we go to our next speaker, can I ask Tim or Amanda to please show the video at this time?
Hi, yes, I am back. I had some major technical issues. But
We have
Tim,
the
if you
video.
Yes, let me play the video. Give me 1 second while I tee that up. I just got back on. So sorry, everyone. Thank you for bearing with us. And I will play that video right now.
Thanks to the ADA, I can now hear in conference rooms and in meetings via hearing loops that connect to the telecoil in my hearing aid. Thanks to the ADA that this is possible. Otherwise, I would not be able to have an avenue to connect to the world. ADA has given me the confidence, and it's also given me opportunities and inclusion in society that I otherwise would not have. ADA is a wonderful right to those who have a variety of disabilities. In my case, I have a hearing impairment since I was born. I've learned over the years of various ways to adjust. However, in this time and generation, now we have technology, and this technology instrumental in helping many people. So technology is expanding the way. And if it wasn't for the ADA, we would not have the strong arm or opportunity to express our needs and our requests to be included, whether that means virtually or whether that means if we're in a public venue, such as a church or a pharmacy, or a retail establishment, or even an airport, we are able to connect via technology that is available to us today. So ADA is an incredible bill that passed to give us right for 30 years. And it keeps evolving, and it just gets better and better. And once more people find out what the ADA can do for us, then people like myself actually are able to advocate for what we need. So it's very important that we pay attention to what's available to us and how we can utilize the law for our benefit. Diversity and inclusion, I'm always for that. And ADA is another strong arm.
Okay, thank you. The ADA is simply a law on paper, and enforcement is up to the authorities, whether it be the courts or the agencies that our next two speakers represent. I want to now ask John Herrian to pick up from there. Thanks, John, for being with us tonight.
Thanks very much, Jerry, and thank you very much to the Hearing Loss Association of America for including myself and others for this wonderful program you put together tonight. Enjoyed a long working relationship with Jerry and others here, and I'm very happy to be able to be with you all this evening. Jerry asked me to cover three different things tonight. The first is the human rights law in New York State and how that law relates to other laws. Also to speak about disability rights and how they can be upheld. And lastly, to provide an example or two related to hearing loss and how the law can be enforced. To the second point, I think disability rights and how they can be upheld are best learned through programs like this one tonight. The opportunity to empower people with knowledge about their rights and how to enforce those rights is really, in my estimation, and this comes from a lawyer who's practiced in this area for 25 years, is in working with groups such as HLAA and other disability rights groups in opportunities where there is an allowance to share what are my rights and how are they enforced, rather than being in front of a judge and at that judge's whimsy. So opportunities like this, like tonight, to share information, to empower people with knowledge, I think really, in my estimation, is the best way to ensure that disability rights are upheld. I want to talk a little bit about the New York State Human Rights Law and its relationship to the Americans with Disabilities Act. An important distinction here, an important takeaway, is how the definition of disability is construed in both laws. And this is important in the context of hearing loss because there can be gradations of hearing loss. So to speak to what I want to cover here, under the Americans with Disabilities Act, the definition of disability requires a substantial limitation of a major life activity. So there's a couple things there. One, the limitation needs to be substantial. And secondly, it needs to affect a major life activity, which clearly includes hearing. So there's no question about that. The issue becomes more involved when we're talking about whether or not the limitation is substantial. So New York State human rights law, similar to other human rights laws around the state, and even more local laws, we have a New York City human rights law as well, can sometimes provide more broad protections for people. And the way in which the New York State human rights law does that is contained in its definition of disability. So when we're talking about the New York State human rights law definition of disability, it merely speaks to physical, medical, or mental impairments. There's no qualifier there that the impairment be substantial or that it affect a major life activity. So what I like to say is we don't get so hung up at the New York State Division of Human Rights as to how disabled are you? How substantial is your hearing impairment as to whether or not you're going to be covered under the law for the protections that are provided there. We don't get hung up on how substantial your hearing loss is. Rather, the focus is on whether or not discrimination took place. And I think that's where the focus should be. So for individuals who are living with hearing loss, individuals who are on this call that advocate on their behalf, I bring this distinction up because it's important to know which venue, which law should I proceed under in order to best ensure that my rights are enforced. Because if you have a hearing impairment that may not be substantial, you may not be covered under the ADA. However, under the state human rights law, there would be coverage there. And again, the focus would more so be on whether or not discrimination took place and not so much on how disabled you are. So it's important to understand how laws provide coverage and protection and where they're most advantageous to individuals, depending on the nature and the severity of their disabilities. Jerry also asked me to speak about how disability rights laws are upheld. I oftentimes give presentations that can get somewhat sophisticated into the weeds on what rights are that people have with regard to employment, access to housing, access to places of public accommodation, what reasonable accommodation standards are. And invariably, after I give those presentations, somebody will raise their hand and say, how do I file a complaint? So I have to be cognizant and aware of the fact that not only is it important to get into the weeds on some of these issues, but it's also important to provide basic information to individuals on how to enforce their rights and where do I get started? You know, I was denied a healthcare provider denied me the use of CART on a interactive platform that I'm using, or denied me a sign language interpreter if that was needed, or an employer denied me an opportunity, an employment opportunity based upon a disability that I have or my hearing loss. How do I go about how do I get that process started? So at the New York State Human Rights Law, it's very easy to file a complaint. You can download a complaint form from our website, which the slide is there now. You can give us a call and ask us to send you a complaint form. We consider ourselves to be a user-friendly alternative to the court system. There are no filing fees that are required, and there's no requirement to have an attorney. So while people can go into state court and file a complaint there, they're going to be faced with filing fees, and they should be represented by counsel. Neither is required under the New York when filing a complaint with the New York State Human Rights Law. The complaint form is designed to be user-friendly for complainants and ask them to tell us what happened and who did it. And once that complaint gets filed, our agency will assign it to an investigator, and we'll also serve that complaint on the respondent, the party that you're alleging discriminated against you. And that respondent will be required to submit a written response to the allegations in the complaint. And the case will be investigated by an investigator who will gather information about the allegations the complainant has made, as well as information from the respondent. And that investigator is then tasked with making a probable cause or a no probable cause determination. Probable cause determination means there's enough there to credit the allegations in your complaint to get the complaint, to move the complaint along to a hearing. And again, we have a prosecutions unit that's staffed with prosecuting attorneys who will prosecute that case on your behalf. And most importantly to understand are that the remedies that are available for the division, New York State Division of Human Rights, are also the same remedies that would be available in state or federal court. So you would have a right to, or you would have a right to have the respondent cease and desist from any unlawful discriminatory practice. Most importantly, you would have a right and a remedy to ensuring that access is provided, that reasonable accommodations are provided. And those could include ensuring that effective means of communications are being provided for persons with hearing loss, including the provision of CART or loops, or if necessary, provision of a sign language interpreter. So the remedies that are available are designed to stop the discrimination, but also to reasonably accommodate the individual with the hearing loss so that they can effectively participate in the programs that are being offered, or effectively access the services and goods that are being provided by a place that's open to the public, or be entitled to an employment opportunity or a housing opportunity that they may have otherwise been denied because of their hearing loss or because of their disability. Lastly, compensatory damages are available under the New York State Human Rights Law, which are not available under Title III of the Americans with Disabilities Act, which covers places of public accommodation. So if you've been denied, or if you've experienced discrimination by a place of public accommodation under the New York State Human Rights Law, compensatory damages are available to compensate you for whatever services were denied, or for whatever the denial of the reasonable accommodation was, or for any mental harm or anguish that you endured because of the discrimination that you experienced. So again, there are advantages to understanding what are the remedies available under certain laws, how do those laws protect people with disabilities, and what's the most effective way to proceed in terms of getting my rights enforced. Lastly, I wanted to include an example. It was a case that was recently decided here in New York by the appellate division that upheld the decision that our agency ordered. And the case involved an individual who was provisionally hired to be a court officer trainee by the Office of Court Administration. And once that individual was hired, they were required to take an auditory exam. And the Office of Court Administration had certain requirements for being able to hear at certain levels. And that individual was using a hearing aid and asked to be able to take the exam with the hearing aid. And the Office of Court Administration in that instance said, no, we do not allow, we have a blanket exemption for court officer trainees based on hearing loss or use of hearing aids. We cannot hire those individuals. So this individual went and filed a complaint with our agency and got a probable cause determination, and the case went before an administrative law judge where there was a recommended order in his favor. And in that order, which was confirmed by the appellate division, there was an award of a $30,000 fine because of the conduct of the employer in this case, as well as an award of $5,000 for mental anguish. So those type of awards show that there's teeth in the law. It shows that people who may otherwise be reluctant to file a complaint, who may not want to be otherwise bothered, really should think twice about that, because the law does have teeth and the law is effective in remedying discrimination, either based on hearing loss or other disabilities. Most importantly, the Office of Court Administration was put on notice that it must reasonably accommodate people with hearing loss and people with other disabilities in order to allow them, if they're otherwise qualified for the job, to have the job. So again, I wanted to include that as a particular example related to hearing loss, related to how laws can be enforced to effectuate the rights of people with disabilities, and to also show the seriousness with which fines and compensatory damages can be issued. So I'm trying to avoid the vicious hook that Jerry gives when time is up, and I'm going to stop here, but I'm happy to answer any questions that folks have. And again, thank you very much for including myself and the Division of Human Rights in this presentation. Thank you, Jerry.
Okay, thank you, John. I want to move on to our third speaker, Mark Fliedner, Disability Rights New York. Mark, if you're with us, can you go ahead?
I'm here. Everybody can see me okay? Or am I good? All right. Well, many thanks, Jerry, and many thanks to HLAA for putting this presentation together. And great thanks to all of you, a really great number of you who tuned in on this evening. As Jerry indicated, I'm the director of what's called the PAIR program, Protection and Advocacy for Individual Rights, at an organization called Disability Rights New York. And this is a great opportunity tonight, not only for me to orient you to what we do at DRNY, but also to orient you to the national system within which we operate, because we understand that many of you are tuning in from other places around the country, and everyone should be able to access a protection and advocacy system in their state by virtue of the information provided on the National Disability Rights Network website, NDRN. So we all operate together under one umbrella. We were all created by Congress and have the power of law behind us to provide a really wide variety of functions. One of them is certainly to provide direct client services to people who call us on an 800 number or send us an email and say, I believe that I have been discriminated against because of my inability to access certain enjoyable parts of community life as a person with a hearing loss, for example, and I'd like you to represent me. Sometimes we're able to do that direct representation all the way through to hearings and such. Sometimes, and I'm grateful to the information John Harrian just provided, and also John Walto, because we may say, you know what, we would like to facilitate you filing a complaint with the State Human Rights Commission. Or, as John referenced, sometimes you're going to be maybe even better off because of your circumstances, looking to see if you have a local, a city municipal human rights law. It happens that the New York City human rights law is arguably one of the most robust human rights laws ever written and enforced anywhere in the world. So we try to guide you toward the best folks to help you. If it's us, we're in. But we also provide a lot of other functions. Our mission includes providing community outreach so that we make sure folks know where we are and how we can assist them. But it's also it's education. Underlying so much of what you all are here to ask us about tonight and share with us tonight is the fact that the community at large, and very often the policymakers who dictate what we do and don't have available to us, have these sort of walls that they put up, and they seem to miss the needs of certain folks. By the way, it also includes the fact that we do systemic work where needed, make a determination that the appropriate thing to do is to file federal litigation, like John Waldo was talking about. Under the ADA, we can also bring claims under the state and city human rights laws in the context of the same complaint, as a matter of fact, to protect your rights in every way possible. But an example of one of the reasons that we sometimes have to file litigation was something that happened early on in the pandemic, and it gives you an example of the kind of work we do. We were hearing from a lot of folks, some with hearing loss and some who identify as deaf, who were unable to digest, to get the information that was being provided by the governor of the state of New York during those critical COVID-19 informational press conferences that were being held daily. We were hearing that these were not folks who had access to closed captioning, or were not folks who were able to understand the closed captioning because they don't speak English. In fact, ASL was their only language. So we reached out to the governor's office. We asked nicely and tried to educate them on where the need was not being met. We went back and nudged a little less nicely. And then we realized that this was a critical matter that needed to be addressed, not only through federal litigation, but through federal litigation that sought a preliminary injunction to force the governor's office to immediately put a live televised ASL interpreter in place. And what can happen if we band together and we share information, and it happened in this case, is that we can result in the making of some great law. And the judge who granted our preliminary injunction and made sure that an ASL interpreter was there the next day, provided us with beautiful language that said, this is exactly the kind of accessibility that is required by the ADA. And that accessibility language is language that we will be able to use going forward, all of us. And in fact, it was used in support of a lawsuit requiring the President of the United States to begin such interpretation in their live telecasts. So that gives you an example of what we can do. I also wanted to let you know that we needed to be really creative this year because we were trying to get resources out to folks as quickly and comprehensively as we could. And we were getting a lot of calls. And so one of the creative ways we tried to do it is we have created over 70 Know Your Rights, Know the Facts fact sheets that we have very easily accessible on our website. If you were to go on and see that you needed to find out how to ask for reasonable accommodations. What were your rights to reasonable accommodations in your workplace? You would click on View Resources on our website. You would click on the particular title of the information that you wanted, and it would immediately open up on a PDF that is printable and available to share with yourself and your employer and others. This is because we know that you advocate daily in every aspect of your life, and that provides you with some guidelines within which to be able to support your advocacy in that regard. I noticed the website that I'm referring to, thank you, I'm looking at the questions, is drny.org, disabilityrightsnewyork.org. And the website that will tell you what is the P&A system in your state is ndrn.org, National Disability Rights Network. I look forward to answering some of the questions that Jerry will pose and that you might have posed. And I also fear Jerry's gong. And so I'm going to stop, but I'm greatly appreciative for the opportunity to be with you all tonight.
You're muted, Jerry.
Jerry, you are muted.
Forgive me. I've been busy noting questions. We have over 50 questions, which doesn't surprise me, given the number of people and the degree of interest in our topic. Let's get to some big questions before little questions. And I'll put this first one to the whole panel. The question has to do with disability rights for people in the workplace. And just raise your hand or start to speak if you'd like to address that question, and you'll be unmuted. But specifically, one question was, at what point is it acceptable or appropriate to ask for accommodation when you begin the application process of job interview? Or are you better off withholding your disability? Is that appropriate? If one of you would like to take that one on, please try to be succinct.
It's such a great question, and I think it lends itself to a whole program on disclosure, whether or not there's a need to disclose that I have a disability, during any point, if it's during the application process or later, in the employment, during the course of employment. And the answer I usually give is if it's not necessary to require a reasonable accommodation, the employer has no business and indeed has no right to ask you about whether or not you have a disability. So it becomes an issue when you do need an accommodation, and the law protects both current employees and qualified applicants for employment. So if you're at the interview stage, I'd argue you're qualified. You've been invited in to interview. And secondly, if you need an accommodation during the interview process in order to be interviewed, or if you anticipate needing an accommodation during the course of your employment, you are certainly free to ask for it at that point. And in fact, the rights to reasonable accommodation attach once you've made that request for accommodation. The law is not designed to make employers to be mind readers. And if your hearing loss is not something that may otherwise be visible to an employer, it may be necessary to say, I have this condition and I need this accommodation in order to assist me to do the functions of the job. Once you've made that request, the rights to that accommodation attach, and there's a process, an interactive process that needs to be undertaken between the employer and the employee. So if at the interview level, at the interview stage, you know that you're going to need that accommodation, you are within your rights to ask for it.
Okay, thank you. A couple of people have asked if there were agencies like yours in their state. And my short answer back to them was to Google Human Rights Colorado or Human Rights Alabama, or call your elected state representatives and ask them to give you that information. But I have a bigger question now about workplace accommodation. Because someone raised the question of, are they going to be written up for asking for accommodation? And I know this is a slippery slope because it can often lead to animosity between the supervisor and the employee. I think it's important in the example we gave of the interview process and in this regard that people keep very careful notes and put as much as they can in writing. But Mark Fleidner, would you like to explain how the law is really protective of people's rights as employees?
Absolutely. It's just another great question. And I think that all of us, unfortunately, are subject to the fact that, and I'm going to argue, need to be ambassadors for changing the fact that disabilities are still, those of us who are people with disabilities tend to face stigma, and we need to stop it. And this is one of the ways we can stop it, because the law protects us from employers stigmatizing and being blaming or retaliatory in some way if we seek accommodations for our disabilities. So that it's very interesting that we asked this question. I completely agree with John Harrian that to be forthright at the outset puts you in an ideal position, not only to assert yourself as someone who is a person with disability who is prepared for the benefit of the employer to get whatever you need to be as constructive and as good an employee as possible, but also because we may be the ones who need to help them be a little bit creative and educate them a little bit on what assistive technology and other means are currently available in order to provide accessibility for us. And I also should probably note that within this P&A system that I referenced, there is a program called Protection and Advocacy for Assistive Technology. And that was created by Congress specifically to address the fact that we need to not only educate employers about what we need in order to make us the most productive employees possible, but also that we need to continue to educate the entire community about creative ways to make us as productive as possible.
Thanks, Mark. Another good question, a broad subject, has to do with airlines and airports. John Waldo, let me turn this one over to you. I think this is a jurisdictional question. Some of it is covered by FAA. Some of it is covered by other jurisdictions, but two separate questions: airline accessibility and airport accessibility. Several airports around the country have now installed hearing loops, but they're still few and far between. John?
Yeah, air travel is really a dicey problem, and here's why. There are two laws out there that work not very well in our favor. One is called the Air Carrier Access Act, which basically requires airlines to do certain things, but it does not allow us to sue the airlines to make them do it. What we do is complain to the Department of Transportation. The last regulations I saw about air travel from the Department of Transportation came out right at the end of the Bush administration, and they're pretty industry friendly. What they say essentially is go to the gate, identify yourself as a person with a hearing loss, and tell the person behind the counter, come find me and let me know if anything important is going on that I missed. Do they do that? I suspect they make a good try at it, but it means you basically, if you've got a 2-hour layover, you can't go have a meal or a drink or something like that. You just got to kind of sit there lest they change your flight. So it's not completely satisfactory, but it's better than nothing. Excuse me. On the plane, again, one thing you can do if you have a hearing loss is board early, which means you can sit where you can sort of see the, lip read the flight attendants and so forth. And I find invariably if I'm flying to LaGuardia, of all silly things, it always means I get a wheelchair waiting for me at the gate, even though I check a box in Southwest Airlines that says, no, I do not need a wheelchair. We also have to cope with what I call the bad ADA. This is the Airline Deregulation Act that basically gives airlines the freedom to do pretty much what they want at the gate, in the air, and so forth, subject only to the Department of Transportation regulations. So, getting better, we hope. It was cool, I thought, that Joe Biden's disability rights platform, when he was running for office, specifically mentioned captioned in-flight entertainment. So he does get the fact that we have specific problems with airlines, and I'm hoping it'll get better. You're muted, Jerry.
I'll add a quick footnote. As when I was doing a fair amount of travel, most airline gate attendants are very accommodating. Go up to them as early as you can, explain that you have a hearing disability, tell them you're going to sit in one of the disability assigned seats close to the where they're standing, and ask them to give you a high sign when it's time for you or your group to board, or if they have an announcement, to call you forward so they can explain to you what it was they said. Moving on, a quick question for John Herrian or Mark Fleidner. One attendee asks, are New Jersey and Pennsylvania, and I would add Connecticut, as accommodating or as helpful with state and local agencies as New York?
Gosh, I wish I had the answer, but I'm not, you got to ask the Pennsylvania, Connecticut, New Jersey folks.
Okay, I just thought I'd put you on the spot.
I know, I can super appreciate that there's 252 participants here, many outside of New York State. So maybe next time we got to add a few more presenters.
Thank you. Back to
Mark,
John.
do you have any thoughts on that, or?
My thought is that you might want to go to ndrn.org, check out and find your P&A system in your state and ask that question to them, because they're going to have a better answer than John and I do off the top of our heads.
Sorry.
All right, John Waldo, another question. You used the term substantial disability. Someone's asking what you meant by that.
The word substantial is in the ADA definition of disability. But when the ADA was amended in 2008, Congress also said, we don't want to fuss too much about how substantial the disability is. Basically, we want to focus on what needs to happen to make it possible for you to, fulfill your significant daily activities. I keep forgetting the jargon. So I don't know about John Herrian, but I've never run into that where somebody said, well, it's not really substantial. There's one case out there that where somebody, I think he might have been in prison, was trying for particular accommodation and had no measurable hearing impairment, but that's a real freak one. That isn't going to happen very often. And again, I think particularly in this Washington case, anybody who goes to the trouble of getting a hearing aid, they're not going to have to fuss about whether they have a disability.
Okay. Another quick question, or question with a quick answer if possible. There are a couple of sectors that are beyond the scope of the ADA and other state and local ordinances or laws. Religious institutions and the federal government, I think, are two. Would one of you like to comment on what we can do to improve accessibility in the court system, and what we should do to try to get more houses of worship to become accessible to us?
It's
Somebody else
go ahead,
does.
John.
Yeah, ADA does exempt religious organizations, and not only the houses of worship themselves, but any business owned by the church. That said, most churches have been conspicuously good about trying to be as accommodating as they can be, even though they're not required to do it by law. Another exemption is truly private organizations. That doesn't mean things that are just hard to get into, like Harvard or Yale, because everybody's potentially eligible for that. What we're talking about in truly private organizations are, you know, like these country clubs where if your grandfather wasn't a member, forget about it, you're never going to get in. That one doesn't really come up too much. In terms of government, executive agencies are not subject to the Americans with Disabilities Act, federal executive agencies, but they are subject to Section 504 of the Rehabilitation Act, the only, which works out about the same. The only two outfits that are really exempt are Congress itself, what a surprise, and federal courts. State courts are subject to Title II of the ADA, so there's some good decisions about required accessibility in state court. In federal court, though, the Federal Judicial Council has come up with a set of policies, basically mirroring ADA. They try to be helpful. They're not terribly enforceable, but again, it's a matter of explaining what you need and why you need it. I mean, every time I go to court and ask for CART, they tell me how wonderful their assistive listening systems are. And I try to explain, I'm sorry, that isn't what I need. And it works, but we got to do it every time.
Okay, here's another pretty big question. Hospitals and healthcare settings, accessibility. Clear masks are not what we're talking about. What we're talking about is the right to CART captioning if it's medically necessary for us to be able to understand what procedures are being done and what information the doctor wants to impart. I know there's a conflict between the ADA and HIPAA law or regulations that restrict some of this to privacy. Could anybody comment fairly succinctly on that topic? I think maybe the best way to answer it is to say, simply ask early and ask often if you need to before you get into that situation, and try to get them to do what you need. But what would you guys say?
I'm glad to address that if you want me to, Jerry. First of all, with regard to the HIPAA regulations, there are obviously regulations that can be waived by an individual patient who's seeking care, and just as you indicated, the earlier the better. So that if you have a situation where you're somebody that needs CART, needs, you know, and with some people, you know, needs a live ASL interpreter, then the most important thing that you can do is advise your healthcare provider as soon as possible, and advise your healthcare provider of your willingness to waive any HIPAA regulations that might preclude them from providing you with what you need. Needless to say, this issue has become so critical in the last year, because what could be more consequential than the conversation between a patient and their doctor? And what could be more consequential than that conversation in the last year, when we had so many healthcare concerns that we needed to address along with COVID-19? So we've been talking a lot about that. We find that educating healthcare providers and healthcare systems goes a great way in a great long way in terms of making them really want to do the right thing for their patients. But that starts with us, and it starts early.
Thank you. Another question, John, you want to add?
I was just going to say that hospitals are known in the plaintiff's bar as the gift that keeps on giving. I mean, there are just constant problems, and somehow filing lawsuits, they have to pay damages, doesn't seem to lead to corrective behavior on their part. So, it's a huge problem. I probably see 10-to-1 complaints about healthcare system, 10-to-1 over everything else combined these days.
Thank you. We have a question about meeting platforms such as this, which is Zoom Pro, which gives us either automated or cart captioning. Not all the platforms do that, but one questioner clearly was not aware that as a result, John's smiling, John Waldo, as a result of our pressure from HLAA and folks like John, Zoom has just announced that they will make captioning available, automatic speech recognition captioning, free as time goes on in the very near future. Right now, you have to apply to Zoom for approval to be included, but pretty soon that will come available to everybody. I have a related Zoom question. I think there's a pretty simple answer, but the question is, can you require legally that faces be shown on these platforms for people who need the speech read? Or is there anything that anyone can do to make the host put the faces up on the screen? New York State, on which I serve on a panel, our official state panel for hearing aids, was not putting the staffers' faces. But I asked, and even though they had antiquated equipment, they managed to get ancillary cameras for some of those people on staff to use when we had to meet online. So some of this is just in the nature of, pressing people to do the right thing. Anybody want to add anything?
I think as the technology, as we've all learned this year, as technology has been expanding and use of these different platforms are expanding, that there are needs for a variety of different types of accommodations, including CART, including making sure a speaker's face is visible for somebody who's lip reading. So I always think that one of the things that I think is a good thing about federal and state law is the elasticity of what reasonable accommodation means. It's not limited in its application, and rather it's broadly construed. So, as technology gets used more and more, and people with disabilities have different types of obstacles accessing it, I think requests for accommodations should be made. And if those requests are ignored or denied, I think complaints and creating some case law around what different types of platforms should be providing in the way of accommodations would be really helpful, so that we can rely on precedent and we can rely on some case law in this area that demonstrates that providers of the platforms, providers of programs that are open to the public, do have obligations to consider and to meet requests for accommodations that are reasonable, so that people with disabilities can effectively participate in the programs.
Okay, a quick question came in regarding that some of the electronic devices coming out from different manufacturers are eliminating the earphone jacks. I have an iPhone that doesn't have an earphone jack, and this person asked whether there's anything we can do to say that what you're doing minimizes our ability to have access to what's being said. I think that Bluetooth is beginning to become very pervasive and will remedy a lot of that issue. But I also think that you can buy an adapter that will give you access if your device doesn't have an audio output jack. it's a question to ask an electronics store like Best Buy, and they can probably help you on that. Anyone have another thought?
The only thing I was going to say to piggyback on John Harrigan, and it applies to this question as well, is I think that as a collective, we need to appeal to their desire for as much commerce as possible. These technological companies, they're trying to make their product as palatable and pleasing to as many people as possible. And the disability community is growing, and it's going to continue to be growing, particularly, actually, frankly, after COVID-19. And the community of people who support disability rights is growing too. So that I think that if we appeal to the fact that this is what your consumer base wants, and educate them in that regard, I think that that's one tool that we have available to us.
Yeah, I think it's always helpful to treat it, if you can, treat it more as a customer service issue before you need to treat it as a civil rights one. But to have both, obviously, is most effective.
John?
The unfortunate odd things about the ADA is that it requires services to be made accessible, but it does not require people to produce accessible products. And believe me, every time you get into a hassle with one of these people, they try to say, this is the product, this is not the service. They tried to argue that the movies were the product, not the service, and so forth. Just one of the things.
Thank you, John. Picking up on that, a question is, as the use of Zoom in education for classrooms advance the technology, because not all children hear equally, I would think complaints by kids might attract attention. What do any of you know about accessibility for children with deafness and being able to hear in the classroom and also online?
I can't say that we've had any complaints at DRNY from students or their parents, but it's a reasonable assumption that there are some that are being limited in their ability to get their complete education for that reason. So it's something that I appreciate the question being asked, because now it's something that I'm going to be looking out for and trying to determine how it's being handled by community school systems.
Thank you. John Waldo has emphasized to me a long time ago that the ADA and related laws entitle us to effective communication and not to a specific type of accessibility. We have a question related to a case that John brought in St. Louis, where a theater goer could not benefit from the assistive listening devices. And that jurisdiction ruled in the plaintiff's favor, and that particular theater had to provide captions on request. John, you want to elaborate?
It was a wonderful case. I mean, the issue there was, did a theater have to provide captioning? First of all, they didn't want to do anything. Then they said, okay, we'll provide captioning at the second Saturday matinee of each performance. And we said, okay, well, we'll give that a good faith try. Well, the very first performance they had, it turned out that a bunch of people, a lot of them from the St. Louis chapter of HLAA, said, hey, wait a minute, we want to go with our friends, we want to go a different day. And it turned out that the second Saturday conflicted like 3 times in the season with the HLAA chapter meeting time. And we pointed that out to the theater and they said, why don't you change your meeting time? And we said, oh, come on, guys. This is absolute nonsense. You're the one that has to make the accommodation, because one of the things the HLAA requires is an equal benefit. And so our argument is that the ability to plan and go with your friends when you want to, not when the theater wants you to, that's a benefit. And not giving us the same entitlement as everybody else is unequal. And we won on that. So
John, I have a follow-up. a follow-up. The questioner wanted to know, is that decision applicable to people who want captions in other jurisdictions?
You know, technically not. Technically, it only applies to the Eighth Circuit Court of Appeal. But as a practical matter, the first court of appeal that decides an issue, that tends to set a national standard. So I'd be very surprised, particularly if it's a decision like this coming from a fairly conservative court. I'd be surprised if other people don't jump on it.
But I would add,
And at the same time, let's not forget the fact that Jerry and I at the same time were working with a Schubert group in New York about creating this Gala Pro system that makes it economically really feasible to offer captioning for every performance of every play. And that's actually one of the things we told the appellate court when we got up there is we said, look, things are moving in the right direction. For goodness sakes, don't stop it now.
thanks, John. The Gala Pro system is one that I've recommended to out-of-town theaters, and I know of at least one or two that have since installed it. There's an upfront cost, but by all means, start by talking to the venues and see what they're willing to do for you. Keep notes, and then go from there as you need to. Another question. An HLA chapter, as many do, have very, very little or no money in the budget. Someone requests ASL interpretation. They can't find someone who'll do it gratis. Are they covered by the undue hardship clause? If they say, no, we can't provide it.
The sad thing about undue hardship, undue burden is that there is no guidance in the case law or the regulations as to how much hardship is undue. And I really wish there was. The Federal Communications Commission has its own guideline that says 2% of annual gross revenue. Anything more than that is an undue hardship and you don't have to do captioning.
But John, we're talking about,
Guideline I use when I'm trying to tell people, is
we're
this something
talking about a local
or not?
HLA chapter with zero money. They would
Well,
have to be.
It seems as though that's a pretty good argument. It's an undue hardship.
John, or Jerry, under the New York State human rights law, undue hardship is a substantial difficulty, or I should say, significant difficulty or expense. So there is, that burden is not a very, that burden, can be difficult to meet for somebody who's saying, oh, we can't afford it. You have to show that the expense is difficult or significant. And that needs to be demonstrated by the entity who was asserting it, so got to be careful with that one. If you're going to, it's easy to say we can't afford it, but if a lawsuit is brought against you, the investigator is going to ask, prove it, open your books. Nobody wants to open their books.
Someone asks if they ask for an ADA accommodation. I think we've kind of covered this. Does the venue have to provide that type of accommodation? I think the answer, unless somebody wants to add anything, is you have to get what you need for effective communication. And if not, you have to explain to them why what they've offered is not adequate and go from there. I wanted to raise a question of my own. Here in my neighborhood, there's a large and quite successful community center that raises a lot of money as a nonprofit in competition with the YMCAs, and have a health club and all kinds of things. They have refused repeatedly to advertise, put on their website, indicate in their invitations to their classes, workshops, special features, movies, whether or not those events are at all accessible. And because you have to be a member or you have to pay a non-member fee for any of those, I don't have any recent information, but it bothers me that I don't think for the most part they do anything. So I guess our only option, correct me if I'm wrong, is trying to get accommodation, keeping records, and if it's denied, then we would approach one of your agencies. Is that correct?
Yeah, I think that's a fair assessment, Jerry. Yeah, absolutely.
Okay, nobody wants to do this, but sometimes we have no choice. This particular community center, we've asked them for years and years, and they basically said, well, what are others doing? And we had this similar situation with a nonprofit theater organization uptown. And about the only thing they seem willing to do is to consider engaging a card operator for a special event Jeff buy tickets for. But I'm talking more about the mainstream, day-to-day, week-to-week classes and events that this organization puts on. Let me see what else we have in the way of questions. In Colorado, the governor had an ASL interpreter at all COVID-19 updates. Then they were shown on Facebook Live. However, the captions were not activated. Is there anything that can be done to compel captions on Facebook Live?
Obviously, that would presume that there was that there were a lot of folks who were only going to access the press conferences via Facebook Live. So, I mean, there's an interesting case to be built if folks came forward and said that by virtue of their unique circumstances, that was their only means, consistent with what we did in our ASL case. I also, I want to just, expand that question and the conversation and say that we're encouraging state and local municipalities to look at accessibility broadly. Sometimes there's an ASL interpreter provided, but the box isn't large enough. The ratio is not appropriate for those who might have sight impairments. So that we are looking to really try and expand the definition of accessibility to make sure it's clear that it's multifaceted, and actually it involves the intersection of various disabilities as well. So it's education.
Here's a tough question. My 60-year-old brother is very hard of hearing and a blue collar worker. He doesn't have a phone. He's not computer literate, only email. He's fully employed and lives alone. He has a barrier to getting a COVID appointment, but is age eligible. No state agencies have in-person access. He lives alone in a city in Connecticut. Family lives too far to help. What can he do?
That's a problematic situation in my estimation. He is being excluded from something that is not only, his right at this point, but is critical to his safety and well-being. I think you should reach out to Disability Rights Connecticut and run that scenario by them. I think it's an important one.
I've also had good experience. We have a home in Connecticut with the Connecticut Division of Human Rights. They're very responsive. So those would be two places to reach out to. Here's an update on looping airports. We only have 2 or 3 minutes left. Sounds like we're all advocating. As Richard Williams says, if not us, who? Looping airports. For the record, Rochester and Grand Rapids are fully looped. I used those examples to ask the Sarasota Airport Board to do a beta test and loop one gate. At the next meeting, the administrator recommended all 13 gates be looped. They were looped and up and running in 2 months. That's the power of our advocacy. I've been after the New York City airports for years. I'm not going to stop being after them, but the more people that request, the closer we're going to be. Someone asked, at what point will health insurance companies cover hearing aids? That's a question better posed to Lisa Hamlin, who's working on that issue for the national office. Another person said that they were told that hearing aids by their insurance company were considered cosmetics. In
Who
fact,
didn't want a hearing aid? They look so great with hearing aids on.
The problem-
Everybody wants to look older.
the problem is that not only are they not considered cosmetics, but they're considered no different than artificial limbs. And that's one reason they're not covered by insurance, right, John?
As you can see, I'm warming up for the arguments I'm going to be making in Washington on this.
Okay. Been looking for one more question to ask in the little bit of time remaining. If you submit a request for accommodation, do you have to have a face-to-face meeting before being denied the accommodation request? No, there's all kinds of ways to ask for accommodation. Start by email, that's the easiest. If not, go visit them. They can hear you, so they'll know what you're asking. Let's see, what else? One more.
You know, I think too, Jerry, that question reflects that there's still a basic need for a lot of information out there in terms of how people can ask for accommodations, you know, what's the best way to do it. So there's still a real basic need for information that people need to be empowered with. But your answer was spot on.
Okay, we're running out of time. My apologies that we couldn't get to more questions. Here are the email addresses for the four of us. By all means, follow up with questions you might have. On behalf of the New York State Association, we thank all of you for tuning in, our panelists for their pointed remarks and advice, and Amanda and her colleagues at the national office for making this possible. As my email signature says, toward a more inclusive and accessible world. Together, guys, we can make it happen. Stay safe and enjoy your evening. Amanda?
Thanks, Jerry. Again, sorry for the beginning technical issues. Thank you so much, Jerry, John Waldo, John Harrion, and Mark for a great presentation. And thank you so much, Lisa Johnson, for amazing captions and cart services. This webinar will be posted to the HLA website at hearingloss.org. And please check hearingloss.org for our future webinars and webinar recordings. Thank you so much for joining us tonight. I hope you have a great rest of your evening. Stay safe and be healthy. Bye-bye.
Bye, everybody.
Bye, everybody.
Thank you.